So I'm sure just about everyone's heard the term restraining order or order of protection. But have you ever wondered what exactly that is? What it means to get one, how you get one, and what the consequences are if you violate? Well, I'm about to tell you everything you need to know about restraining orders in the state of New Jersey. Hi, my name is Daniel M. Rosenberg. I'm a criminal defense attorney and the founding partner of Rosenberg, Perry & Associates. It is also my personal goal and passion to provide information and education on the criminal justice system before people become involved and entrenched in the system. So while the vast majority of our practice consists of criminal defense, we also handle civil matters with a criminal flair. So in addition to defending individuals charged with crimes, we also defend individuals charged with domestic violence allegations. And in addition to being charged with a crime, our clients are oftentimes served with a restraining order. So first things first, what exactly is a domestic violence restraining order in New Jersey? A restraining order is a civil complaint that prevents contact or communication between two parties who are in a domestic relationship. Now, this is not a criminal charge. It is a civil proceeding. If you get a separate criminal charge, you will have something on your criminal record. If you only have a restraining order, there is nothing on your criminal record. Restraining orders in New Jersey come in two flavors, temporary and final. And both a final and temporary restraining order are governed by the Prevention of Domestic Violence Act here in New Jersey. That lays out what is required in order to get a restraining order and what protections can be put in place by a judge hearing the case. Worthy of note is, New Jersey restraining orders don't prevent people from being 100 feet or 1,000 feet away from someone. There is no distance requirement. It is you can't have any contact or communication with this person, and you can't go to any of these places where they may or may not reside or work. Now that we know what a restraining order is, how do you obtain a restraining order in New Jersey? Well, the first thing you do is you apply for a temporary restraining order. An application for a temporary restraining order complaint can be made verbally or in writing. If it's after hours, at night, oftentimes police or law enforcement will put the alleged victim on the phone who will communicate with the judge verbally. If it's during business hours, oftentimes the alleged victim will be required to write out their complaint, and that information will be provided to a judge who will then take testimony from the complaining witness. In order to obtain a temporary restraining order, a complaining witness must establish three things. First, that they're in a domestic relationship with the other person. What that means is, if you have an issue with your neighbor, you can't get a restraining order. You have an issue with someone you work with, you can't get a restraining order. You have an issue with someone you live with, that's a domestic relationship. An issue with your father, an issue with your sister, an issue with your child. Domestic relationships all apply. The second thing you need to establish is a predicate act. A predicate act in the domestic violence statute is a nuanced term, and it refers to 19 specific potential crimes or offenses that qualify. Meaning, if you commit the act of simple assault, which is a predicate act, you can obtain a restraining order. On the other hand, if you commit the act of disorderly conduct, which is not a predicate act, you cannot qualify for a restraining order. So assuming that you can establish a domestic relationship and a predicate act, there must be a finding that there's a need for restraints. In essence, what's going on here is the judge is saying, I'm only hearing from one party. I'm going to find out if this is something we need to put protections in immediately, and then if so, we're going to come back in a short period of time and have a full-blown hearing to figure out what's going on. In addition, the judge will issue temporary restrictions on the defendant. Those temporary restrictions will include no contact with the complaining witness, not being able to return to the residence of the complaining witness, and not being able to contact or communicate with the complaining witness through any third parties. The statute requires an initial hearing to be scheduled within 10 days of the issuance of the temporary restraining order. So after a temporary restraining order is issued, how does it become a final restraining order? As I mentioned earlier, within 10 days, a hearing needs to be scheduled. Oftentimes, this hearing doesn't take place within 10 days, but it's required to be scheduled within that time period. What's worthy of note is that in most proceedings, you are entitled to what's called discovery. That is the exchange of information with the other side. Restraining order hearings are referred to as summary matters, which means there's no requirement for the exchange of discovery. So when you show up to this hearing, you're figuring out and learning what the other side has during the proceeding. It's pretty scary stuff sometimes. So if after the restraining order hearing, the judge enters the final restraining order, what happens next? The judge imposes consequences, which include not being able to contact or communicate with the alleged victim. You can't go to their house. The alleged victim also gets to say, well, I don't want him or her to speak to my brother, my cousin, my best friend. The judge can add all of those people to the restraining order. The complaining witness can also say, I don't want this person coming to my job, my work, my cousin's house, because I go there a lot. All of those places can be added to the final restraining order. Judge can also order a psychological evaluation, a drug and alcohol evaluation, counseling, anger management, things of that nature. Judge can also order the defendant to pay the legal fees for any attorney that the plaintiff hired in order to prosecute the restraining order. Finally, if a final restraining order is entered, the defendant forfeits their right to own or possess weapons forever. After the final restraining order is issued, if the defendant violates that restraining order, it is referred to as a contempt charge. And depending on the conduct, it varies between a misdemeanor and a felony. The consequences for violating a restraining order for a first offense do not require jail time. A second violation requires a mandatory 30 days in the county jail. And if you're wondering how to get a final restraining order removed, there's two ways. One, the complaining witness comes to court and says, I no longer want this restraining order. Or secondly, the defendant can make an application. It's called a Carfagno motion. And that motion essentially says, Judge, there's no need for restraints any longer. I'd like this to be dismissed. These are just some of the things that you need to know about restraining orders in New Jersey. So if you, a friend or family member, has been charged with an act of domestic violence or has been served with a restraining order, we can help. Contact our office. We'll take the time we need to give you solid advice and counsel so that you can make an informed decision and do what's in your best interest. And if you liked what's in this video, please like and subscribe to our YouTube channel. And if there's any topics you'd like to learn more about, please leave a comment below or contact my office. I'd love to hear about it. We are criminal trial attorneys. We have your back. That's what we do.